legal team defending former President Trump was physically ejected from a federal trial after what witnesses are calling the most explosive meltdown they've ever seen from attorneys in a high-profile case. The trigger? The prosecution introduced a single email that the defense had previously sworn under oath did not exist. Witnesses report attorneys being escorted out by federal marshals, while one of them loudly accused the judge of presiding over a kangaroo court. This was far more than just another contentious moment in the ongoing legal saga. It involved licensed attorneys risking professional discipline, contempt charges, and potentially even criminal liability, all while losing control to the point that a federal judge had no choice but to remove them from the courtroom. When marshals are physically leading lawyers out while the judge threatens to refer them to the bar, it signals that something truly unprecedented has occurred. It's remarkable and hard to believe that officers of the court, trained in law school and sworn in after passing the bar, could so completely lose their professional composure in a manner experts say could end careers. Here's what's been unfolding. The defense's strategy has relied heavily on maintaining credibility with the court, arguing that any issues with document retention were inadvertent, that their client acted based on legal advice, and that the prosecution's efforts were politically motivated. For weeks, the team presented themselves as disciplined professionals, adhering to courtroom protocols and carefully defending their client against perceived overreach. According to Politico's December 10th coverage, the defense had successfully seoned doubt over parts of the government's timeline and even got several prosecution witnesses to acknowledge ambiguities in email chains and document handling. Their approach was effective enough that some legal analysts suggested Trump might have a viable path to establishing reasonable doubt on certain charges. But this is where the tension hit a breaking point. For days, the prosecution had been methodically building toward a key piece of evidence. They had set the stage with testimony on document retention policies, laid out timelines through phone records, and constructed a narrative suggesting intentional obstruction rather than simple oversight. Then, on the morning of December 10th, prosecutors informed the judge that they needed to introduce a newly authenticated email, part of a larger document production that hadn't yet been shown to the jury. And let's be honest, when prosecutors announce one more piece of evidence and the defense team immediately starts objecting before even seeing it, you know things are about to explode. Here's where it gets really intense. Multiple reporters from CBS, CNN, and the Associated Press inside the courtroom described how the prosecution handed copies of the email to the judge, the jury, and the defense table all at once. The email dated August 2022 fell right in the middle of the period when the attorneys were negotiating with the Justice Department over the return of classified materials. Within seconds of reading it, the lead defense attorney, identified in reports as Trump's primary trial counsel, stood and demanded an immediate sidebar. The judge agreed, and all the attorneys gathered at the bench for what was supposed to be a quiet conference out of the jury's hearing. That's when everything unraveled. According to CNN's legal correspondent, who was close enough to catch parts of the exchange, Trump's attorney raised his voice almost immediately, insisting that the email was fabricated and accusing the government of manufacturing evidence. The judge warned him to calm down, but the attorney only grew louder, demanding that the court declare a mistrial on the spot. The judge then called a recess and had the jury removed from the courtroom. Once the jury was gone and the proceedings resumed on the record, that's when the situation truly exploded. Speaking directly into the courtroom microphone for the official record, the lead defense counsel accused the prosecution of withholding exculpatory evidence, manufacturing documents, and engaging in misconduct he claimed amounted to criminal fraud on the court. The judge pressed him to clarify exactly what he meant, and that's when the attorney made a statement that would ultimately unravel his case. He asserted, this is crucial that his legal team had conducted a thorough review of all emails from that period, and that this very email, just introduced by the prosecution, did not exist in any of the document productions they had received. He stated that his team had never seen it before this moment. Then the prosecutor stood and dropped a bombshell. Calmly, she told the court that this email had actually been produced to the defense back in September during the third document production. It was clearly identified in the production index as item 4732. And in a stunning revelation, the defense had even referenced the same email thread in one of their own pretrial motions, just conveniently leaving out the most damaging portion. The prosecutor handed the judge a copy of the defense's motion with the email thread highlighted, proving they not only received it, but had already used parts of it in their filings. Reporters inside the courtroom described the atmosphere as electric with tension, and Trump's attorney reportedly turned bright red. Instead of stepping back or conferring with his team, he doubled down. He accused the prosecutor of lying, claiming this was a setup, and insisted the email in their files must have been altered after production. The judge, clearly losing patience, asked if he was asserting that the prosecution had fabricated federal evidence. The attorney replied, "Yes, absolutely. That's exactly what I'm alleging." At this point, the second-chair defense attorney tried to pull him back to the table, tugging on his sleeve, but the lead counsel shook him off and pressed on. He declared that the entire prosecution team should be investigated, claimed this was worse than anything in Watergate, and even said the judge herself was complicit if she allowed the fraudulent evidence to be presented to the jury. That's when the judge had apparently heard enough. In a voice reporters described as icy but controlled, she told Trump's attorney that he was now in contempt of court and needed to sit down immediately or he would be removed. Instead of complying, the attorney declared he would not be silenced, insisting that someone needed to expose what was happening in the courtroom, and that he was willing to go to jail to protect his client's constitutional rights. The judge then looked directly at the federal marshals and said one word: "Remove him." Two marshals approached the defense table, and at that moment, the second attorney stood up and began shouting that this was a violation of Trump's Sixth Amendment right to counsel, claiming the judge was proving the system was rigged against them. The judge held up her hand, pointed at him, and said, "Him too." Both attorneys were escorted from the courtroom, while one of them shouted back that this was a kangaroo court and that everyone would see the truth. A junior attorney from the team remained at the defense table, frozen in shock. This isn't the first time attorneys defending Trump have found themselves in positions that destroy professional reputations. Consider Rudy Giuliani. Once celebrated as America's mayor, he became a disbarred lawyer facing bankruptcy after years of making false claims about election fraud on Trump's behalf. Giuliani's decades-old career ended with lost licenses in New York and D.C., plus a $148 million defamation judgment, all because he refused to stop lying even when the evidence proved him wrong. Then there's Sidney Powell, whose outrageous claims about voting machines led to defamation suits, criminal charges in Georgia, and a lasting reputation as a national legal laughingstock. Powell went from respected federal prosecutor to a figure synonymous with conspiracy theories and baseless allegations. Jenna Ellis also suffered professional consequences. She pleaded guilty in the Georgia case, admitted to making false statements about the 2020 election, and was censured by the Colorado bar. She acknowledged relying on others without verifying facts, ultimately violating her professional obligations while representing Trump. Even John Eastman, who authored the memo outlining how Pence could refuse to certify electoral votes, now faces disbarment proceedings in California and criminal charges elsewhere. His legal career has been effectively destroyed because he advanced a legal theory that serious constitutional scholars deemed baseless. Now, it appears that Trump's current trial attorneys may be joining this list. Lawyers who thought they could bend the rules, make outrageous claims, and face no consequences as long as they were defending Trump. The pattern is striking. Every attorney who crosses ethical lines while defending him ends up professionally ruined. So, what specifically triggered the immediate ejection? It comes down to one thing: making a factual claim to the court that was demonstrably false, and then refusing to back down when confronted with proof. Legal ethics experts emphasize that attorneys have a duty of candor to the tribunal, meaning they cannot knowingly make false statements to a judge. Crossing this line leaves no room for negotiation. Removal, becomes the only option. When Trump's lead attorney claimed his team had never received that email, he was making a factual representation to the court. The prosecutor immediately proved that statement false, presenting production records from the defense's own motion that cited the email thread. At that point, the attorney had a professional duty to acknowledge the mistake, apologize, and move forward. Instead, he accused the prosecution of fabricating evidence, a charge of criminal misconduct that requires concrete proof, not defensive deflection. Here's the critical moment. The judge asked him directly if he was formally accusing the government of manufacturing evidence, giving him a chance to walk it back. He said yes. According to legal analysts, that was the line no competent attorney crosses. You do not accuse prosecutors of criminal behavior without extraordinary evidence, especially when the record clearly shows your own statement was false. The judge then gave a clear order: sit down and be quiet. Another chance to stop the spiral. He refused. At that point, ejection wasn't just justified, it was mandatory. A judge cannot allow an attorney to continue disrupting proceedings, making false statements, and defying direct orders. Legal experts also noted that when the second attorney stood up and joined the shouting, his fate was sealed as well. Once a judge orders someone removed and you step into the chaos, removal becomes inevitable. This leaves Trump in an extraordinarily difficult position. On one hand, he now faces a complex federal trial with only a junior attorney who wasn't prepared to serve as lead counsel. That attorney must manage the remainder of the trial, handle cross-examinations, make legal arguments, and protect Trump's interests, all without the preparation, strategy, and experience the ejected attorneys had developed. You know, a case of this magnitude that's nearly impossible. On the other hand, Trump's entire defense strategy just collapsed in the most public and damaging way imaginable. His attorneys didn't merely lose an argument. They were thrown out of court for making false statements and erupting in outrage. That image is now seared into the minds of the jurors. It sends a message that the defense was so weak, so indefensible, that even his own lawyers couldn't face the evidence without melting down. And the worst part, there's no one doing it. Trump can try to bring in new attorneys mid-trial, which would require asking for a continuance the judge is unlikely to grant. Even if she agreed, starting over would expose the jury to the fact that his original legal team imploded so catastrophically that a complete replacement was necessary. That hardly inspires confidence. Alternatively, he could continue with the remaining junior attorney, potentially supplemented by another member of his broader legal team, but that leaves him severely undermanned against experienced federal prosecutors who just scored a massive psychological victory. Every option is fraught with peril. The defense just inflicted perhaps the most damaging self-inflicted wound imaginable in a criminal trial. The fallout is sending shockwaves through Trump's world and the broader legal community. According to multiple reports, the conservative legal movement is divided. Some praise the attorney's passion, while others are horrified by the lack of professionalism. Meanwhile, some Trump supporters online claim the ejection proves the trial is rigged and that his lawyers were removed because they were winning. Others, including conservative attorneys, are openly questioning how anyone could have thought this strategy would help their client. Meanwhile, the legal ethics community is united in condemning what happened. Former prosecutors and defense attorneys from across the political spectrum told multiple outlets that this conduct is career-ending. The attorneys involved will almost certainly face bar complaints, could be held in contempt beyond the immediate ejection, and might face sanctions, including fines or even suspension of their licenses. Andrew Weissman, former FBI general counsel and prosecutor, told MSNBC that in his decades of practice, he had never seen anything quite like this. He emphasized that making false statements, accusing prosecutors of crimes without evidence, and defying a judge's direct order would normally result in a referral to the state bar and could even trigger criminal contempt proceedings. The tension escalated further during the lunch recess when Trump posted on Truth Social, attacking the judge personally, calling her a partisan hack and praising his attorneys as heroes for standing up to corruption. Legal experts immediately pointed out that Trump publicly criticizing the judge while his attorneys had just been removed for similar misconduct showed either a complete disregard for or misunderstanding of the consequences of courtroom behavior. Former federal judge Nancy Gertner told CNN that Trump's statement could be used as evidence suggesting the attorney's actions were part of a deliberate strategy to create appealable errors or manufacture a mistrial, which could make matters even worse if the judge investigates whether the contempt was coordinated. Legal and ethics experts emphasize that the implications of this unprecedented moment go far beyond a single bad day in court. First and foremost, how does Trump continue this trial? Veteran trial attorneys note that losing an entire, fully prepared legal team mid-trial is catastrophic. The remaining attorney lacks the same command of the evidence, hasn't prepared cross-examinations, and doesn't have the strategic framework developed over months. This leaves Trump at a severe disadvantage for the rest of the trial. Some legal analysts told Politico that Trump should seriously reconsider whether to take the stand in his own defense, because without experienced counsel to prep him and guide his testimony, the risk of self-incrimination rises dramatically. Second, there's the bar ethics dimension. Multiple state bar associations could open investigations into the attorney's conduct. Legal ethics professor Stephen Gillers of NYU Law School told The Washington Post that making false statements to a tribunal is one of the most serious violations an attorney can commit. He noted that lawyers can be disbarred for far less severe conduct. And in this case, the public nature of the meltdown, coupled with the clear record of what was said, makes defending their actions nearly impossible. This wasn't a misunderstanding or a heat-of-the-moment mistake. They made specific factual claims that were immediately disproven, then escalated instead of correcting course. Third, there are the criminal contempt implications. The judge could refer both attorneys for criminal contempt proceedings, which carry potential jail time. While this is rare for attorney misconduct, former prosecutors point out that refusing a direct court order after being found in contempt moves the situation into that territory. The attorneys may now need to hire their own criminal defense counsel to defend against potential contempt charges stemming from their conduct while representing Trump. So, let's break down what this could mean. This isn't just about two lawyers having a bad day. It carries serious consequences for Trump's immediate legal situation, the broader pattern of attorney misconduct in his cases, and the integrity of the judicial system. First, the immediate trial impact. Trump now faces the remainder of his trial with a severely weakened legal team, right after the prosecution introduced potentially devastating evidence, and after the jury witnessed his attorneys being physically removed from the courtroom for making false statements and erupting in outrage. Legal observers following the trial told multiple outlets that this single incident may have eliminated whatever chance Trump had at creating reasonable doubt. Juries tend to draw negative inferences when defense attorneys behave this way, seeing it as a sign of desperation and consciousness of guilt. Looking at the broader implications for Trump's other cases, this incident could shape how attorneys approach representing him in the future. Competent lawyers are likely to be extremely hesitant to take on his cases if they see that doing so could put their licenses at risk. According to Reuters, several law firms that had considered representing Trump in other matters have now declined, citing concerns over whether they could maintain ethical representation given his demands and public statements. With each high-profile misstep, the pool of qualified attorneys willing to represent Trump continues to shrink. Beyond Trump specifically, this sends a warning to all attorneys about the consequences of letting client loyalty override professional obligations. Bar associations and judges are watching these cases closely. The message is clear. You cannot lie to judges. You cannot make baseless accusations. And you cannot refuse direct court orders, no matter who your client is or how high-profile the case. This isn't just about one trial. It's about whether the legal system can function when attorneys abandon professional standards in service of a client's scorched earth strategy. If these attorneys face no meaningful consequences, if they can lie, accuse prosecutors of crimes without evidence, defy orders, and walk away with nothing more than a fine or slap on the wrist, then we are essentially saying courtroom rules don't apply when representing someone powerful. That would open the door for aggressive, unethical legal tactics to become normalized with no real downside. This isn't just about Trump's lawyers. It's about whether every attorney, regardless of their client's status, must follow the same rules of professional conduct. Here's the situation. Trump's attorneys were physically ejected from a federal courtroom by marshals after making demonstrably false statements to the judge, accusing prosecutors of manufacturing evidence without proof and refusing direct orders to be quiet. This was more than a courtroom meltdown. It was a complete breakdown of professional standards, a pattern that seems to follow anyone entering Trump's orbit. When lawyers would rather be dragged out of court than face the evidence, the jury takes notice and it tells them everything they need to know about the strength of the defense. If these attorneys face no serious consequences, then the precedent is clear. There are no real rules for lawyers representing powerful clients. The next few days will be critical. Trump must figure out how to continue this trial with a decimated legal team. The ejected attorneys will face potential bar complaints and criminal contempt proceedings, and the jury will have to decide what they just witnessed and what it means for the credibility of the defense. The stakes have never been higher. The consequences of attorney misconduct never more public, and the path forward never more uncertain. Keep a close eye.